The question is that Clause 2 stand part. I call Chris Hipkins.
Thank you very much, Mr Chair. I'm very happy to take a call on Clause 2, which is the commencement clause of the bill. A nice, simple, straightforward clause which reads, "The Act comes into force on the day after, on the day after the date on which it receives the royal assent." So that seems relatively straightforward. What does that actually mean? I'll read it out again because I completely botched it up the first time. The Act comes into force on the day after the date on which it receives the royal assent.
Okay.
Now that might seem relatively straightforward. The royal assent would typically happen within a few days of the bill being passed by Parliament, through all of its stages by Parliament, through the Governor-General effectively signing it on behalf of the Sovereign, the Queen of New Zealand, who is, of course, Queen Elizabeth. However, there's no guarantee that, in fact, the royal assent will be given. So all New Zealanders work under the assumption that if a law is passed by the Parliament, that as of right, automatically, it is going to become the law of New Zealand. That's not correct. In fact, we have the royal prerogative, which does allow the sovereign of the country to not provide royal assent. And that has happened not in New Zealand, but it has happened in other jurisdictions who have a similar procedure. So if I look at the Parliament of Belgium, for example, we will look at the Parliament of Belgium, where the issue of the royal assent came up because a law was passed by Parliament, and from memory I think it was around gay marriage, which the King of Belgium objected to, and therefore refused to provide the royal assent. And so therefore the will of the people, through the democratically elected Parliament, was thwarted, although perhaps it wasn't. Because what the Parliament of Belgium did, and this is quite a novel approach, is they effectively removed the King from office for a day. The law was signed.
Order. I wouldn't want the member to feel that I was being pedantic anyway, but it's been drawn to my attention that speculating as to what the sovereign may do at any one time, it not only is a long way away from the ambit of this particular clause, but may draw disrespect towards the sovereign, and he may wish to check his standings orders in relation to that, particularly 118. But I'd ask him to stick fairly closely to, as he has conceded, the very narrow nature of Clause 2.
Absolutely, Mr Speaker, and I mean no disrespect to the sovereign whatsoever, and I wish to make that abundantly clear. However, the royal assent is granted by the Sovereign of New Zealand, which is Queen Elizabeth II or the Governor-General. And the point that I am merely making is that there is no guarantee that the royal assent would be given by the Sovereign. And I'm not speculating in any way that the Sovereign may or may not give the royal assent. I am simply pointing out that there is precedent in other jurisdictions who follow the same legal process of the royal assent not being given. And in the case of Belgium, what that resulted in was the Parliament effectively taking the sovereignty for themselves for a short period of time, which allowed the Prime Minister to sign the law, and then, of course, the sovereign was reinstated. That was the precedent in Belgium. Now, we're very fortunate in New Zealand that the royal assent, as far as I know, has never been refused under the royal prerogative, and that, of course, is a very good thing, because the principle that we have in New Zealand is that the Parliament, the will of the people through the Parliament, even when the minority are right and the majority are wrong, the will of the people through the majority in the Parliament will be given the royal assent, and that will become the law. So this bill will effectively come into force at some point within the next few days, probably early next week. I would think that the next opportunity for the Governor-General to sign the law would come into force. Of course, we are debating this bill on the 21st of May, despite the fact that the rest of the country have moved on. It is now the 22nd of May. The records, the Hansard records of the House, if this bill is passed, and by the looks of the votes it is going to be passed with a reasonably comfortable margin, the records will show that this was passed on the 21st. The royal assent is therefore not, one would assume that the royal assent might be given on the 22nd. That won't be the case, because in fact by the time the bill makes its way to the Governor-General for the royal assent, it would be at least the 23rd 3rd, I would think. It's not going to go to the Governor-General today, normal people time, which is the 22nd. It's the 21st, according to the House. It'll be the 23rd tomorrow by the time the bill is prepared and ready, but that, of course, is a weekend. So it would be the 24th, 25th on Monday, which would probably be the first opportunity for this law to actually come into force. This is quite correct. This is when the royal assent will take place. At the earliest opportunity, this bill could come into force. At the earliest opportunity that it would come into force would be Monday, when you work through the logical sequence of the dates that we're talking about. The reality would be, if the Governor-General were for some reason unavailable to sign the legislation, it may not come into effect on Monday, and it may be further down the track. There are, of course, other provisions that mean that if the Governor-General is not available on Monday, they could be signed by someone.
I call Tracy Martin.